You may be wondering still, who is an expert? There are some questions to answer. For instance, do you know if standards and accreditations exist in your field, and do you meet the standards in your field as an expert? Did you personally obtain available accreditations in your specialty? And did you earn the license required by that specialty? Did you obtain any expected or available certifications in your specialty? You should consider additional work to prepare yourself. Lawyers and the courts they serve want expert witnesses to look good on paper, to sound good in court, and to legitimately have the qualifications to be there. You will frequently hear the term admissibility. A judge determines whether to admit you and your credentials and your work into the court. The judge has what is called the gatekeeper role and decides whether to allow you to present your work and your opinions in the courtroom. You may think you did exemplary work, but the opposing attorney may successfully present legal reasons why the judge should not admit your work into evidence. Inadmissibility may not indicate that your work was poor, but it does declare that your work did not meet legal standards. Rejecting your work before it is even presented will be a damaging loss to your side and a great victory for the other side. Inadmissibility will successfully keep your work from even being considered by the jurors. Your retaining attorney has to deal with legal considerations regarding admissibility. However, you can help to clarify your work and provide your opinion with a solid foundation by presenting it well, preparing it to meet standards, and performing your work carefully. You cannot scrimp on care, and your work must meet the norms and standards of your industry. If you express an opinion in court that seems straightforward to you, that opinion may actually sound ridiculous if you based it on incomplete, poorly documented, or otherwise shoddy procedures. What does your job history say about you? Extensive industry experience will help you most when making a transition from just an industry expert to a litigation consultant. Jurors will easily recognize your expertise if they learn that you have worked as an industry expert for years. The opposing attorneys will then find it difficult to discredit those credentials. Perhaps you play a key role in academia. Perhaps you have written extensively in learned journals about the subject of your testimony. While this can support in one fashion your claim to credentials, it also can provide attorneys with a weakness to exploit. Academic experience alone, without hands-on work, can seem only theoretical and can lead to rigorous cross-examination. Attorneys may capitalize on this weakness by presenting hypothetical questions that can be difficult during testimony because of your lack of real-world experience. Lack of industry experience can come across as the ivory tower syndrome, a weakness found often in academic expert witnesses. Jurors may find you in those conditions less believable and your opinions less acceptable. One time in a murder trial in the Midwest, the district attorney reminded me to speak simply because the jurors were farmers and not big city folk. When testifying in court, you have to know your facts and opinions as well as your audience. So a tactic to remember here is let the jury pool guide you toward ramping up or toning down your words and your phrases. Have you ever worked for a federal or state government agency? If you have worked for a law enforcement agency or governmental commission, you may have a built-in acceptability to jurors. On the other hand, jurors may have a bias against you because you worked for the government. Nevertheless, government employee does bring a notable credential to the table on your behalf. A combination of regulatory agency, academic, and industry experience will strongly support you in your role as an expert witness.